Yeah, please, your lordship. My lord, I beg to mention item number 7 to 10, lordship. That's an income tax appeal, my lord.
7 to 10.
Lordship.
7 to 10, we are appealing for the appeal.
My lord,
Let him speak.
Bolia.
Let you respond.
yes.
May I?
Okay, yeah.
My lord, this is 2024 matter. My lord, we have sent for instruction. My lord, we have communicated. My lord, but the concerned officer, he is on election duty. He has been appointed as election observer outside the state. So we need some time, my lord, for getting our instruction and to file a reply.
You are for the appellants.
I am for the
Respondent.
respondent,
On income tax
Lord.
department.
my lord.
May I make one submission, my
Yeah,
lord?
sure.
I don't as basically object to this, but your lordship kindly let me raise my grievance before your lordship. In
That's right, but so that we'll not be able to decide it.
let them submit
Consider it on
afterwards.
the day when the next time when the hearing takes.
You know, in that event, my lord, I respectfully said it can be fixed on 17th June. If my lord, 18th June, 17th is a holiday, 18th we can do it.
My lord.
Agreed?
17th, I have some other.
No, 18. 17 is a holiday.
Let it after 28th. After 20th of June. 21st.
After 20.
Yes, yes. On any day. 24th? 24th?
Then kindly, 21st,
No, 28th.
28th, or 27th. Let it be 27, my learned friend agrees to 27. 27 June.
What's the problem in 18?
My lord, has the other matter fixed in outlying benches, my lord, on 18th of my lord, June.
19?
19 would be.
19.
Lord.
Yes, sir.
Huh?
19.
19. 19
applied.
June. 19 June, ठीक है.
June, this one. 19th.
19 June. 20 is a holiday. So what is this 20?
20th is the holiday.
No.
No.
It's a restricted
20th is
holiday.
not
June.
No, no, restricted.
It's
It's
okay.
a working day here.
Let it be on 19th. No issue.
No. 19.
19th of June.
Yes.
Okay, then it must have
20th क्या है? 20th क्या है? 20th?
has submitted that.
20th क्या है?
They may be saying, I don't know.
20th it doesn't show any holiday.
However,
20th कर दीजिए. That is restricted holiday होगा. इसमें भी restricted holiday. 20th कर दीजिए.
yeah,
It's all right.
19th.
19th. 19th we can.
Deeply applied.
appointed is on election duty. Therefore, the matter may be approved for an appropriate day. And then consider appealing for the appellant raise for listing the matter on 19th of June 2024. When consent for the income tax department has no objection, let this matter be fixed for hearing on 19th of June 2024.
Deeply applied.
May I please, Lordship? Lordship, with regard to item number 6, Lordship, Justice Nair was appointed as amicus curiae in this case, Lordship. So Lordship may not like to take up this admission in MBBS 6.
Those series matter.
Lordship.
Another bench.
May I please, Lordship?
Yeah.
Lordship, I beg to mention for listing, my lord. This is fresh matter, my lord. Yesterday matter was listed before court number 3, my lord, but it was left over, my lord. Matter
It
is
was left out. So left out if the roster is of that court number 3, how
Lordship,
can?
yesterday, Lordship, before the court number division bench 2, my lord,
Yes,
listed. It was left over, my lord.
leftover case, how can it be listed, sir? That can be
Should,
listed
this
for
is
in that
urgent.
bench only. How in this bench can it be listed? When the
Lordship,
roster is fixed for that bench.
Lordship, this matter is related to division bench 1, my lord. Rateable, my lord.
So then, until and unless that division bench releases it, how can it be listed here, sir? So you make a mention there, sir.
Most of it.
May I please, your lordship, I beg to mention for listing upon writ petition in orders column.
What's the urgency?
Urgency, my lord, we have challenged the rule 42B of the plastic waste management. Our business has come to a standstill since 2022.
That
The
is a
matter
pending-
was last listed on 12/6/2023.
Pending matter.
Lordship,
Next week, may get it fixed next week.
Please, my lord, with the consent of the other side, I beg to mention item number 11 and 12, my lord. We are led by my lord senior counsel, my lord, is some have difficulty, my lord.
I can't take it.
Another bench.
No, my
Next week, sir.
Item number 14, my lord. Matter, what about it?
वैसे बात करते हैं। फिर उसके बाद में
My lord, so far as item number 14 is concerned, my lord Justice Naya may not be pleased to take up the matter. My lord.
Sorry. I'm sorry.
item number 14.
14.
Sorry.
So if justice, whether ruling is having exception, why they are listing it? Why they are listing
Also,
it?
my name was.
So at least.
They can-
It is there. Why they are listing it?
One side.
You are talking them.
All these matters, more argument there.
Item number 14,
14.
the supplemental list.
Yes.
Then, another bench.
Last.
Yes. Is there any?
Daily list for orders item 1.
Only thing that portal, they are undertaking that is on that portal. If somebody is individual.
May it please your lordships.
Yes.
Lordship, this PI we have filed for seeking effective implementation of 12(1)(c) of the IT Act, lordship. Since the filing of this PI, lordship, and after various orders of this court, we have successfully got admission for 44 school children in various private unaided schools in the state. Apart from that, lordship, we had several other prayers which have not been addressed effectively
those
till
prayers?
date.
What
Yes,
are those
lordship.
prayers?
Lordship will kindly come to page, lordship. Page 26 of my PI, lordship. The first prayer, lordship, we had was, we wanted directions from this court to the state respondents to appoint a nodal officer at district level for the purpose of 12(1)(c), lordship, who shall play a role in raising awareness regarding the admission process under the section 12(1)(c) of the RTA, assist parents for applications and take up action against non-compliant schools within the district, and whose contact number shall be displayed on the website of the Education Department, required to be pasted on prominent places in the notice board of unaided schools and widely publicized to media. Second prayer, lordship, is issue directions to the state respondents to upload a list of students admitted under section 12(1)(c) of the Act across Assam for the academic year 23-24 in the website of the State Education Department by 20th May 23, as per their own clause, lordship, as per part B, clause 11 of the OM, which is annexed in the PI, lordship.
So the direction has already been issued. They are not
No,
displaying the list.
Lordship, it has not been taken up yet, lordship.
2, 3, 4.
Anything, lordship, to do with the website portal or to bring the data online?
But as per their reply, they are
Yes.
going to launch it in after the elections in
No,
June.
lordship, this prayer has been there for a very long time. May I bring lord?
But if they are now, they are assuring that they are going to
Lordship.
launch a portal in June 2024, what to do?
Lordship, they have stated that there is already a portal. And the last 3-4 hearings, my friend has always said before the court that there is a portal, but which is not open to the public as yet, lordship. This portal is not for the Education Department. It is for the public, lordship. Lordship, this portal is for these children to apply for the admissions and the time is already over. This is the month when
The
the children.
last occasion,
Yes, Lordship.
this court has taken note of this fact.
Yes,
They have
Lordship.
made a statement, then what remains? Now
Lordship.
you want that today itself it should be
No, Lord,
launched, then
that is not our prayer. Our prayer is the time has already gone by. 1 year has gone by and again they are seeking time, Lordship.
if now they are ready to do it, now what?
So Lordship, since the elections is over, Lordship will fix up a date after 2
Madam,
weeks.
model code of conduct is still there up to 4th of June. That
So
we all are
after-
aware.
Yes, Lordship.
Let them wait for 4th of June and after that of substantial time, if they are not going to comply with, then certainly we'll take care of that.
Lordship, we have been waiting for so long. Only after various orders of this court,
Understand
some
that,
things
but-
have moved in here, Lordship.
This petition is of 2023.
23, Lordship, but prior to that, this, Lordship, this act came into force in 2010. In Assam, it was implemented at 11. From 11, nothing happened. Only after we filed two
So if
PILs,
now
Lordship.
they are ready to do it.
It is,
What's
yes,
the
Lordship, I
ultimately-
leave it to your Lordship, but they have to move, Lordship. They cannot just keep on taking time again and again. 9 months have gone by to just set up a portal, Lordship, where we are still
Now,
struggling.
if they have assured us that they are going to launch it after these elections, after model code of conduct is over, what else would you like to have? No, we'll pass an order today
Lordship,
itself.
what
We
about
launch
the
it.
children who are missing out the chance to apply for
Yes,
admission
that's
this
right.
year?
It's a matter of concern, but now if they have come with this, then what to do?
So Lordship, we can ask the children, wait for another year, so then apply.
Who said it? Who said
There
it?
is no portal to apply, Lordship. Lordship, may kindly come to page 43, Lordship, of my PIL. It is the activity calendar. May draw Lordship's attention to serial 11, Lordship. Clause 11 of page 43, Lordship.
Mr. Consul, last occasion, this court has granted some time to you regarding the non-filling for this non-minority schools.
Yes.
What you have done?
We have had the reports. I got the reports up till April 18th. I have the reports. There were some schools where admissions were still going on. Last night, when I had a discussion with the secretary himself, he was seeking for around 10 days time where we can get all these reports from all these schools as to the number of
Now it's-
applications received.
10 days are already passed.
Madam,
That
no,
is-
I had a discussion yesterday, madam. The election part, madam, it was closed, office was closed yesterday. We had a meeting scheduled yesterday. Government offices were closed. We could not get the reports on time. If it could be, I have to,
Yesterday, day before yesterday, it was closed. Not
no, the election was day before yesterday, but those who had, the persons who were on the election duty, madam, for when yesterday was the office, they were given a leave. So they did not report, we could not get all the reports together. 10 days time, my lord, or 7 days time, from every school, we'll have the report as to the number of applications received, how it was displayed, and the number of students which were admitted, who have been admitted. In fact, my lord, I have got reports up till April 18th. It is only up till April 18th. Some schools admissions were not over. So therefore, in those columns, it has been shown as 0. When I raised the question, how can it be 0 or there can be no compliance? They said that the admissions are still going on. 25% applications have not come so many. So those applications, once scrutinized, will be admitted. And if no one has applied, that will be given as no applications received. Or if anybody has applied and did not fulfill the criteria, what criteria was not fulfilled will also be brought up. So that is what we are trying to do, so that every school will be
court
under the
order
school.
is there.
Lordship would kindly have this part, my lord, para 9.
Yes.
Para 9 and Lordship will have the admissions are going on. Para 6, my lord, till that time we were not getting the objections. Any objections? Para 6. No objections received, that applications were being rejected. And para 7, my lord, admissions were going on and therefore it was fixed in May. Now admissions have gone up till 30th of April in some schools. In fact, my lord, in some of the schools, what happens is pre-primary section, we have given the 25%, the schools had given. These people are being promoted to class 1. So in class 1, no fresh admissions can come in from the outside. We cannot have applications. Some schools could not have those applications. So even that data we are trying to collect, why no applications were sought for from them? And if they can justify that appropriate number of students have been promoted to class 1.
Yes.
Then, my
Lordship,
lord,
may I bring Lordship,
cannot
just a second, Lordship. 421 of the affidavit we had filed up. Lordship, may kindly take it up for a moment.
Yes.
Lordship, there is the need for the centralized online admission portal. The responsibility is on the government, not on the schools, Lordship. I may be allowed to read this paragraph. The deponent most humbly states that the National Commission for Protection of Child Rights, New Delhi, in its standard operating procedure for implementation of Section 12(1)(c) of the RT Act, dated 25/6/21, which was directed by the Honorable Supreme Court by order dated 9/5/2022, in so and so to be complied by all states and union territories, had laid down concrete suggestions to ensure effective implementation of the 12(1)(c). The aforesaid order of the apex court is annexed here. When the apex court has already laid down the order, the SOP is there. Is there a need for the state to come up with a new SOP and change the procedure, Lordship? They are not following the NCPC/RC guidelines.
So they have changed that procedure. SOP.
They are doing it by themselves. They do not want to.
Where
bring
is
it-
that change SOP?
That is what right now he is submitting before the court. They are not following the procedure laid down by the
Ma'am,
Supreme Court, Lordship.
Ma'am, on the last occasion, the court has taken note of this fact in para number 8 of the order sheet. Please
Yes, Lordship.
go through it.
Now, I have
What
gone
is
through,
this?
Lordship, what I'm trying to say, everything they are submitted, what he is submitting is not online. Let him, whatever he has submitted
What he
today.
is, please read this para, what he has said. Mr. R. Majumdar, learned training of the department submits that a dedicated portal of the Department of School Education for effective implementation of the provisions of 12(1)(c) 2009 Act has been made ready, and that such portal will come into effect after ensuing parliamentary elections gets over as per the decision of the cabinet at presently the model code of conduct of election is in force. So now, after this assurance, what do you want now? What order you want?
Lordship will wait for them to bring the portal online and show
That's
it
why
to
what
us,
we are
which
saying-
has not come till date, Lordship.
Yes, that's right. They are
We'll wait
admitting
for it,
here.
Lordship.
This is the own admission of the education department in this order itself.
So Lordship will fix up a date and let him show us the portal, Lordship. And let it be open to the students who are going to benefit, not for the interdepartmental processes, Lordship.
Open portal, if it's there, then everybody can access it.
Let us see, Lordship, even we are waiting for it.
That's what we have submitted in the initially, what we have said.
We'll leave it to this court to see that it comes up, Lordship.
Yeah, sure, why not? Okay. This court. I ordered it at 2/4/2024. After taking into consideration the submissions made on behalf of the party, has directed the school education department to furnish up-to-date status regarding the admissions of the school students in unaided and non-minority schools in the state of Assam as prescribed in section 12(1)(c) of the Act of 2009. Learned Counsel appearing for the school education department has submitted that the information is under process, and by the next date of hearing, the said information will be furnished before this court. Yes, and make it sure that after 4th June, this portal should be list on 10th of June, 2024.
Obliged.
Item 2.
Left. My lord, power grid, my lord, they install their electric line, my lord. And for that, my lord, they have right of way, my lord, under Telegraph Act, Read Electricity Act. My lord, Government of India has issued the guidelines, my lord, in 2015, my lord, that is at page 178, my lord. But if they-
Where the learned single judge?
My lord, I'm coming, my lord. Yeah, only, my lord, because
You are-
their prayer is, my lord, to pay adequate compensation as per the government guideline.
You are aggrieved by this observation made by the learned single.
Only this is, my lord,
In
page
fact-
200, page 212.
Internal page 10 of the judgment.
My lord,
Internal page 10 of the judgment.
yes, page 11.
Not
Page 11 of
11.
the judgment.
Yeah, 11, yes.
The last sentence, my lord, only.
Yes,
There
the
is no doubt, my lord.
Yeah, read this whole para.
Yes.
Read
My-
this. Mr.
The-
Tiwari,
Mr.
learned
Tiwari,
single.
Learned Senior Counsel, Petitioner point out that by notification letters so Government of Assam Power Electricity Department guideline dated 15/10/2015 issued by Ministry of Power. Central Government of India has made its application restricted to the extend new transmission line projects where construction started after 15/10/15.
Now,
There is no
this
doubt
is
to the fact that-
this is the the line
Yes,
which starts, there is no doubt.
no doubt, yes.
Yes.
There is no doubt to the fact that, but in order to make the basis of assessment, guideline can be taken into consideration, keeping in view the technicality involved in the issue of determination of the compensation in as much as the said compensation cannot be equated with one under Land Acquisition Act, as in most of the cases, ownership of the lands has always remained with the petitioner. Except, my lord, this is the line only which we are opposing, my lord. Except the area of land under the tower based, which shall have to be abandoned.
तो इसमें
My lord, their prayer is, my lord, as per Government of India guidelines, adequate compensation should be paid to them. And that is to, my lord, under Telegraph Act, my lord, Supreme Court has also said it is the district judge who is to decide, my lord.
Fine.
My lord, because not the High Court. So, my lord, as per the
The
guidelines.
High Court has not granted any compensation. The High Court has simply relegated them to the
Yes,
concerned authorities.
This is against the guideline, my lord. This is against the guideline. Their prayer is, my lord, to pay adequate compensation as per the guidelines. And guideline, if you have lost to see page 178.
Yes, guidelines are applicable only to those work who start after 15/10/2015.
Yes,
This is what your prayer is.
yes.
But the learned single judge has not granted that relief, that grant them compensation as per these guidelines. They have simply said, take guidance from these guidelines. That's all.
No, but here what happened, I am speaking, my lord. If your lordship see that prayer, page 61, read please on prayer. Prayer in the read.
Yeah.
Issue a writ in the nature of mandate directing respondents to ensure payment of adequate compensation to prisoners and others similarly situated like them in terms of the guidelines of Government of India dated 15/10/15.
Fine.
So they want this, my lord.
But
And
the
guidelines
court
say-
has not granted this relief.
No, the guideline says, my lord, if you also see guideline number, page 178, Roman 2, my lord.
Yes.
First, your lordship may see Roman 1.
Yes.
Compensation at the rate of 85% of land value determined by the district magistrate or any other authority based on circular guideline value of stamp rates for tower based area impacted severely due to installation of tower flight structure. This is one.
Yes.
Second one, my lord. Compensation toward diminution of the land value in the right of the right of way. This is, my lord, what, my lord, the single judge interpreted. Right of way corridor due to laying transmission line and imposing certain restrictions would be decided by the states as per categorization type of land in different places of states, subject to a maximum of 50% of land value determined based on the circle rate, guideline value or stamp rate. So they are to get 15%, my lord. If, my lord, this observation of single judge is to be right, my lord, they have to abandon it, means it is to be acquired. But no, that is the, my lord, that is the
Simply a
meaning.
passing observation, sir.
My lord, that is
Simply
the-
a
my lord,
passing observation.
no, it is not
That
abandoned. my lord.
doesn't mean that they'll get the compensation as per the Acquisition Act. That doesn't mean.
My lord, abandon means, my lord, they need not abandon, my lord, because they can use it. My lord, as per guidelines, my lord, they can use it. But they will get 15% compensation, my lord.
Except the
because-
area land under tower which shall have to be abandoned. Abandoned means they have said that this can't be used for any purpose except that the tower is there.
My lord, it is cultivable land, they can cultivate it.
beneath the tower.
Yes.
How can it be?
No, that can be, my lord. That can be, my lord. That can be because the guidelines and also state, my lord, how much like, because it's a very big area.
This except the area land under the tower base. That's the only thing. Yes, in between the lines of the two poles, certainly they can use it for cultivation.
Yes, my lord.
But so far as regarding tower base is concerned, suppose if the tower base circumference is around 15 feet or 30 feet, they can't use it.
No, for that, my lord, clause 1 will be applied. That is correct.
So we don't understand how you are aggrieved by this order. The court has not granted any relief to them. They have simply said, "Okay, go to the district collector. If you are aggrieved, then go to the district judge." And a passing remark is there that yes, 15/12/2015, our guidelines are not applicable, but
My lord,
the authority can take guidance from it for
My
the
lord,
purpose of
it is,
fixing compensation. That's all.
my lord, it is, my lord, what happened, my lord, and just saying, my lord, they say it is right of, my lord, wide, my lord, right of way, my lord, between the two towers, my lord, the land is there, that will not be affected, they can exist.
Yes.
Yes, my lord, that only, my lord, that is the difficulty, my lord, it is interpreted in that way, my lord.
So how you just show us where is the right of way? Even the word is mentioned about right of way. These are the directions. First, go to the following directions.
Yes.
First direction is the individual petitioner shall approach the concerned deputy commissioner specifying identifying the land which falls within the right of way
Yes.
of the where the concerned deputy commissioner in respective district shall verify the genuineness of the claim through the circle officer. In the event that claim is genuine, damage shall be assessed as per the guideline. If any petitioner are aggrieved by the assessment made by the deputy shall take necessary shelter under section 16, thereby moving territorial district judge for enhancement of the damages in order to invoke jurisdiction of the territorial under section so and so, there must be a dispute in respect of compensation. Similarly, the respondent is aggrieved, the assessment by the liberty to approach the district judge concerned. If the district authority has already assessed the compensation are not satisfied such claim, are entitled to approach the concerned district judge 1885.
Madam.
Mr. Tiwari, London Senior Counsel, for the petitioner pointed out why notification dated so and so issued by the government of the guidelines should be. There is no doubt to that effect. Now, what this mean? They have admitted that guidelines 15/12/2015, the compensation can't be paid to the persons in whose agriculture land this construction started prior to 15/12/2015, but the authority can take guidance for the purpose of determining the compensation. That's all.
Yes.
This is what the learned single judge has said.
Only thing.
How
that
you are
last sentence,
Sir,
my lord,
except the area land under the tower base, which shall have to be abandoned. What is the circumstances of that tower base? How much? How much land is covered in that tower base? 15 feet, 20 feet, 10 feet, how much? That can't be used. Obviously, that can't be used.
that comes under one, my lord. If that be so, my lord, then 85% land value has been given. Whatever. One.
Whatever it may be, the compensation has to be determined by the authorities concerned. And if they determine the compensation applying the, what to say, this incorrect, this compensation by incorrect, applying the incorrect guidelines, you can very well challenge it before the district judge under section 16. How do you are concerned?
They mean it, my lord, that in between the towers, my lord, I mean,
The tower base and land under the tower base, very specific they have said, not about the between the land situated between the two towers. It not speaks about that.
Our way to. Ours 80%.
We don't feel anything. Okay.
My lord,
Yes,
this can be, my lord, this can be. This
What?
can be explained, my lord. That-
so there is, it is self-explanatory. There is no need for that, sir. What to explain? What do you suggest? What to explain?
My lord, it applies to Roman one, my lord, only.
My lord, then,
Roman one only, my lord. Because I did a tower base.
may I clarify,
Did a tower.
that may be adversely affected to you, sir. Roman one, what we feel, it can't be
Roman one.
that you are asking that which the learned single judge is not granted.
No.
They have simply said, assess the compensation, anybody aggrieved, approach the district judge, taking some guidance from these guidelines, that's all.
No.
That's all, nothing.
They're confusing or they are trying to delay it. Use that the name of the support the company. What not been gone. And the other, he just, I don't know why we didn't have because it's not effective. Only talk about the relationship. Next page, not one man both for the son of identifying the man which both within the right. So it could be that will exclude the son. Not be given.
Nothing. Okay. Yes, what do you want to say?
If my lord is not clarifying the judgment of learned single judge, then my lord, we are perfectly okay with it. But any clarification of the judgment to the effect, my lord, the way it is being suggested by my esteemed colleague, would create a.
What they have suggested?
My lord,
You
the
please-
learned single judge has simply spoken about the following the spirit of these guidelines while deciding the compensation, and we are perfectly okay with that. Because this is what it was meant to be. Because had there been a mechanical approach, that guidelines are only prospective in terms of the notification of the government of Assam.
That is there, sir. Certainly, these guidelines are not applicable in your case where the construction started prior to 15/10/2015. But the learned single judges simply observed that the authorities can take guidance from that
Yes.
guidelines for the purpose of determining the compensation.
Well,
That's
I'll
what
just
we
put-
understand.
I'll speak few words on this. This has been the consistent approach of the various high courts, including the Supreme Court. What happened was, my lord, prior to these guidelines, that is prior to 2015, there was no law governing the field.
Yeah.
Because Section 10D of the Telegraph Act only talks about giving adequate compensation for the damages. Matters went to the court, and Supreme Court laid down the Levisha principle in 2007. The Levisha principle is Supreme Court said that when when the transmission lines are laid over the agricultural field, then it is that the value of the land gets diminished. This is the Levisha principle. There is a diminution in the value of land. And then Supreme Court said the diminution in the value of land has got so many facets. This is a wonderful paragraph.
Fine.
Supreme Court in the Levisha case in 2007 set aside the full bench judgment of the Kerala High Court. So a Levisha principle was consistently followed by 3 other benches of the Supreme Court. 2008, 2011,
Certainly for the purpose of.
and in 2017,
for the
interestingly,
purpose
my
of
lord,
determining compensation,
Yeah.
there must be some guidelines.
yes, in
So that-
2017,
Authority
my lord,
can be
only
applicable.
one more line, my lord. In 2017, another case came up before the Supreme Court. At that time, guidelines were already there. And that was a case wherein the work had already commenced prior to the guidelines, and the work was also over, but adequate compensation was not given in 2017. Supreme Court said, we gave the principle earlier, and now you have got the guidelines. So the guidelines at least can be taken into consideration for the purpose of assessment of compensation. That's it.
This writ appeal is filed by the appellant being agreed with the order dated 20th of January 2020, passed by the learned single judge in WPC number 3776 of the 2018. Full stop. The respondents have filed the said writ petition with the grievance that they are affected during the period 2014/2016 while the power transmission lines were erected by the appellants. It was the case of the respondents that in process of erection of tower and stringing of power transmission line, the respondents suffered both surface damages over the respective land of the appellants, and in case some of the appellants respondents land covered by the lower footings had to be abandoned. It is contended on behalf of the respondents that most of the persons were using the land for residential, cultivation purposes, but on account of erection of transmission lines, the appellants, the respondents have not been able to use the land for residential as well as agriculture purposes. It was prayed in the writ petition that the appellants be directed to pay adequate compensation to them. Learned single judge, after hearing the counsel for the parties, have disposed of the writ petition filed by the respondents with direction that the respondent shall approach the concerned deputy commissioner for the purpose of determination of compensation, and if any of the party is aggrieved by the said determination, they can very well approach, they can very well invoke the jurisdiction of the district judge under section 16 of the Telegraph Act. Full stop. Para. Considering the submission made on behalf of the counsel for the respondents that the guidelines issued by the government of as per the notification, it was contended on behalf of the counsel for the petitioner that respondent that the notification dated 10/3/2017 issued by the government of Assam specifies that the guidelines dated 15/10/2015 issued by the Ministry of Power, Central Government of India, is applicable only in cases where the new transmission line / projects started after 15/10/2015. Full stop. The learned single judge has observed that there is no doubt that those guidelines are applicable only in cases where the construction started after 15/10/2015. However, made an observation that those guidelines can be taken into consideration for the purpose of determination of compensation. Para. This writ appeal is filed on behalf of the appellants seeking clarification of the observation made by the learned single judge in the impugned order having gone through the impugned order and after taking into consideration the controversy involved and the controversy involved, we are of the view that the impugned order doesn't require any clarification, hence this appeal is dismissed. IA number so and so is also disposed of.
Item number 3.
Lordship should kindly come to the impugned judgment. From para 3 and 4, Lordship will notice that the petitioner scored 102.09 and cutoff mark was, my lord, 102.21. Now, apart from anything else, my lord, I was given negative marking also. Now, even if that negative marking is also not resorted to, then I qualify. Because then I become a 102.59. And the cutoff mark is 102.2. And my lord, Learned Single Judge also did not notice one aspect.
Yeah.
There was already an interim order whereby one post was directed not to be filled.
That's right, but the Learned Single
No,
Judge
Mr.
has come to
Lordship,
the
can you see-
conclusion that the whatever the this examiner has decided that this is the correct answer. Then
In fact, that would lay our hands to one judgment of the Supreme Court,
yeah,
where the Honorable Supreme Court has said, my lord, 226 court is not admitted in subsequent. Yes, yes.
that is
So 2019, 16 SCC 663.
Nineteen.
We have not attempted a wrong answer. What
no,
we said
that's
was
right.
correct.
That's right. That's right. That is also the Learned Single Judge has not said that you attempted the wrong answer, but they have simply said that both the questions are may be correct, both the questions, because yes, larger part of the Assam is touching the eastern side of the eastern side to or two states, Arunachal,
Actually, 3 states.
3 states, Manipur, Nagaland, and Arunachal. And
No. In fact, my lord, if you lordship to kindly come to page 24, para 12 of the judgment.
yeah,
Learned Single Judge himself says, my lord. Para 12, page 24.
yeah, there is no dispute
There
that
is
this
no dispute that state of Assam is bordered by Arunachal Pradesh in the north and in the east by Nagaland, Arunachal Pradesh. And
Manipur.
Clarify.
the Learned Single Judge accepts, my lord. This.
Oh, no doubt. And further,
Yes.
the major portion of the eastern boundary
Yes.
as discernible from Annexure 12 is covered by the state of Manipur.
No.
The options are given as a Manipur, Arunachal, and Meghalaya and Tripura. To a question. Number 86. Meghalaya and Tripura are not at all on the eastern boundary of
Yes,
Assam,
yes.
where Manipur is in the eastern boundary. Therefore, the decision of question settled to treat the Manipur to the concern opinion of the Arunachal so and so cannot be said to be glaring defect. And this court in exercise of judicial review cannot replace the decision more so than
My lord, equity knows no halfway.
that's right. But it seems
Lordship will have the judgment, my lord. I think this will give enough scope for your lordships to interfere. Para 20.
para
20.
this 2019-16.
Yes, my lord.
Yeah.
Page 670. Para 20. The question, however, arises whether even if there is no legal right to demand re-evaluation as of right, would there arise circumstance which leave the court in any doubt at all? A grave injustice may be occasioned to a writ applicant in certain circumstances. The case may arise where even though there is no provision for re-evaluation, it turns out that despite giving correct answer, no marks are awarded. No doubt this must be confined to case where there is no dispute about correctness of the answer. Further, if there is any doubt the doubt should be resolved in favor of the examining body rather than in favor of the candidate. Now, this is important. The wide power under Article 226 may continue to be available even though there is no provision for re-evaluation in a situation where a candidate, despite having given correct answer, and about which there cannot be even the slightest manner of doubt, he is treated as having given a wrong answer, and consequently the candidate is found is entitled to any.
No doubt, no doubt. But one caveat here.
Yeah.
No doubt this must be confined to a case where there is no dispute about the correctness of the answer.
Yes.
Here,
That is
there
correct,
is-
my lord. The learned singular
Both-
also admits.
both the answers are correct, in fact,
Yes.
because they have not
My lord,
clearly mentioned in
That's why,
in
my
the
lord.
question that which larger part of this eastern side is going there. Then only probably your answer would be correct.
My lord, what I am on is I'm on a slightly different point, my lord, subject to what your lordship may say. I am on that negative marking. I having not answered a wrong answer.
But now,
Therefore, not giving me mark is okay.
yeah, but
But
negative
giving me negative mark is an aspect which perhaps lordship would like to look into. Because 0.50,
Please vote that. This is examiner. And this plan. Google investigate. Google investigate. And yeah, this is very, very Google has also not.
and my lord, the apprehension expressed by the learned single judge at para 14.
Yeah.
That there will be a toxic, that is not there because there is already an interim order whereby one.
But ultimately, sir, if one person is, suppose in your case, they say that this negative parking was wrong.
Yes.
Or he is entitled for 1 mark for that purpose, then whole result has to be rebellious.
No, my lord. One post is there.
One post is there,
From
but
one
other
person from
persons are
below
also.
will be affected. One person from below of the merit list. Or one person. Well, I can appreciate going by the trend of the judgment or preponderance of view of the Honorable Supreme Court. All right, the doubt has to be resolved in favor of the examining court. All right, to that extent, I'll not get a mark. But when of that negative marking part, that a lot will have to.
Okay, we'll consider.
Yes, that's the
We'll
only aspect.
We'll consider.
Lordship's permission, my lord,
Yes.
a recent judgment of the, my lord, the Rajasthan High Court. এই গোটেইখিনি বস্তু discuss কৰিছে।
Don't you have any recent judgment of Assam High Court?
My lord, on this aspect, this is the most recent, my lord, the one being tested now. There, my lord,
One which your lordship will be delivering will be the latest of the Assam.
at page 8 of the judgment, my lord, para 11 onwards, my lord, the entire matter has been discussed as to what can be done in such a
Page 8.
page 8 of the judgment, para 11 onwards. At this nascent juncture, prior to delving into the arena of the assessment of the final answer key dated so and so with regard to the objection raised juxtaposed with the answer displaced pursuant to the consideration of the sale objection. This court deems it appropriate to explicit the following key legal considerations which often envelop matters concerning assessment of answer keys in public examination. Scope of judicial review under Article 226 of the Constitution of India, the exceptional circumstance, when can an interference be made? The exceptional circumstance, what is palpably and demonstrably erroneous, and limitations of court is matters of judicial review of answer keys.
We'll consider. We can.
Obliged, my lord.
Yes.
Item 4.
Lordship and Lord can ask me to take it.
Yes, yes, yes. So what are your instructions?
Is out of the four project, Lordship, three are there at preliminary stage. Only one he requested stay till January 2025.
Development and demonstration of primary established for
A is a preliminary stage, Lordship. A, C and D.
A, C, and D are at the preliminary stage. So
Preliminary.
preliminary stage, you can engage any other person.
In B,
In that, if it is not at midway or near completion, you can very well sound implementation, elimination of standard issue harms during silent operation. And this is going to be,
till January 2025.
where is that?
Timeline, last column, timeline.
12 months, that is from 8th of January, date of release of first installment. And suppose if it is not completed by then, then
This probability is there.
give us the assurance that you are going to transfer him in January 2025 will pass an order.
This is from the administrative office that has to come from the headquarters.
So after this completion of this project, certainly, and then no new assignment to this person that again you will say, and apart from this A, B, A, C, and D, which
May
are at the
start.
primary stage or
Please
preliminary
start in the
stage,
meantime.
you engage some other. Yes, ma'am.
My lord, what they have given, I do not know. They are saying that, my lord, as per my instruction, my lord, he has been engaged in a project in January 2024.
Yeah.
Where he is acting as a liaison officer.
Liaison officer.
Liaison officer, not such kind of responsibility is given to him. So in any way, he can be relieved at any time, my lord.
You have this communication and file a response to this, that you are simply a liaison officer.
Yes, my lord. Yesterday, I took the instruction, my lord. He has given a.
Give us a affidavit, a liaison officer, and then if he is not involved in the actual whatever the research program or whatever it may
Yes,
be.
my lord. That is
Liaison
what I
officer
want.
can, anybody can be appointed as liaison.
I am also not sure, but let me take that section.
My lord, your lordship can dispose it of with this direction also. That
Let us show, we'll pass a effective order for that. Why to dispose it of in hurry?
lord.
Supply us the that details that you are simply a liaison officer and not involved actual whatever this operation, then we can very well pass. Tuesday,
Lord,
but you also confirm it. If he is only a liaison officer, then why to force it? Ultimately, if a person is not willing to do work, how can you take work from him?
Lord,
If he is not willing to work. Tuesday,
much of.
For hearing, item 5.
It's not taken for land. That land was given. But he is that important. He's party officer. The revenue is that.
yes, Mr. You are occupying the land of these persons. If you don't want to vacate it, give them some compensation. And it's an admission by the circle officer there that their lands are, you have constructed some residential quarters or some buildings on their land. Yeah.
they approved before the civil authority to demarcate their lands. And as the civil authority had not acted upon their letter, they approved before this honorable. And this honorable directed the material officer to demarcate their land.
Yeah.
Now, pursuant to that, the material officer was of the view that the land as claimed by them, has been occupied by the railroad.
That is their land.
Now, Lord, whether it is their land or not, that is defined issue. Now, they instead of instituting any civil suit, they approach before the High Court by through a writ application.
That's right, but
Now, they are claiming their right title interest only on the basis of the revenue record. So they have to establish their right title and interest by instituting a civil suit only. So, without instituting a civil suit, straightway they approach before this honorable court. And if the lordship goes to the writ petition, the lordship will find that the writ petition was drafted in such a manner as if it is a plague. Where the
But if the facts which are not in fact, more or less admitted, then what to do?
no, we have not admitted yet.
The court can very well pass that on. Sir. Who has supplied this?
You have given. You have given this judgment.
Yeah.
Paragraph five.
I believe the market, yeah, not any form of conflict.
This was way back in the year 1968. It was launched. 1958.
50. The transfer with the railways is subsequent to.
This land was in fact acquired or by in 1958.
Yes. Yes. Can I
1958.
just come in, my lord? Let my learned friend show that this portion of the land was acquired for them. That's all.
But sir, ultimately you approached this court in the year 2000 against this whatever the
Initially,
acquisition.
we approached, the learned single judge gave a direction to the circle officer.
To get the land
Yes.
demarcated.
And based on that, my lord, we came for the second time. And my lord, where
Initially,
is the
when
disputed
you-
question of fact, my lord? That I have to go to civil court to establish my right, title and interest. You are saying it's an acquired land. Please produce that document whereby it shows that this particular
But
duck number was acquired. That's all.
Second.
No.
That's it. Okay. अच्छा देव while 2013 the document
That notification we have annexed, my lord, this particular duck was not acquired.
Why you have not appeared before the learned single judge?
Page 31,
Page?
31.
No. Your presence is not there before the learned single judge.
Can they file a review?
No, paragraph 8, we start from paragraph 8.
Paragraph 8.
8, that is the transfer of the case.
Hmm.
That Sri Ali Learned Council referring the draft Sita to the revenue record has submitted that there is no ambiguity on the ownership of the land in question. They want to establish their ownership only on the basis of the revenue report. The same accordingly reveals that the dark numbers of the plot of land in question is within the land owned by the petitioner. The reliance is also made to the order dated 31/8/2030 issued by the circuit officer, wherein the report of the Lat Mandal has been referred to in the said order. It has been reflected that the land in question are in the occupation of the railway department, which had constructed roads, quarter, and drains. On behalf of the railway, an affidavit in opposition has been filed on 11/4/2014. The stand taken in that affidavit is that a large chunk of the land was acquired by the railway through the state government of Assam in the year 1958. And the plot in question is within acquired land. On the other hand, the learned counsel for the petitioner, by referring to the acquired land, on the other hand, referring to the notification under section 4 of the proceeding before on 21/6/1958 submits that the disposition of the said notification, description of the said notification does not include the land in question. Rather, the darks of the petitioner's land has been shown to be a part of the boundary of the western side of the acquired land.
Yes.
Now, so, Lord, it's a disputed question of fact. Their case is that they are the owner of with respect to this land, and they are claiming their ownership through the revenue record. And they appealed before the High Court for declaration of their right title interest. And after declaration, and the restoration of the possession. And the learned single judge Willard passed an order whereby the railway authority was directed to hand over the possession to the to them or to pay compensation. Lord, they have to establish their right, title, interest with respect to this land. Lord. And the establishment of right, title, and interest can only be done by instituting a civil suit. So without instituting a civil suit, they straightway they approach before the High Court for declaration of the right, title, of interest, though it is not specifically stated so, but for handing over the land. Now, Miller, if your lordship come to page 39, that is the read application.
Yes,
Now your lordship come to page 53, paragraph, paragraph 16 of the read application. No, madam.
yes,
That the petitioner begs to submit that the respondent authorities have no right and the power to deprive the petitioner from his right to property without any authority law, any authority law. In the instant case, respondent authorities has illegally taken possession of the land of the petitioners, KP Patta land, without their consent and without making any payment of compensation. As such, the respondent authorities may be directed to vacate the land mentioned in the Schedule A. No. Now, your prayer is at page 54.
yes,
Now, we are to come to paragraph page 54, their prayer. A writ of mandamus should not be issued directing the directing and commanding the respondent, particularly respondent number 1 to 3, to vacate the land mentioned in the Schedule A and A of the petition and hand over the vacate position to the petitioner. As if it is a civil suit, Lord. Page 55, 2, no? Now, a writ like nature should be issued directing the respondent authority to remove all the construction made over the said land mentioned in Schedule A of the petitioner and to hand over the vacant position of the petitioner for the interest of the justice. A writ in the nature should not be issued declaring, they are seeking a declaration, declaring that the deprivation of the petitioner from the property without authority of law, without paying any compensation as illegal, null and void. Now, next paragraph, next page is 56. They have given the schedule of the land. as if it is a plate, you know.
Yes.
Without adducing any evidence whatsoever. No title deed, nothing else. Straightway they approach before this one also go through a writ application for declaration of their right title and information. Whether this is their land or not, well, if we assume that the railway has enforced this land, it does not mean that this land belongs to the petitioner. For that reason, petitioners to come with civil suit for declaration of their right title and interest. It's summary way, my lord.
Yes.
That is the case, my case, my lord.
May it please your lordship.
And railway has constructed, their quarter in the year 1980.
1980.
And they approved before this honorable in 2013.
My lord, we kindly.
97,
Yeah.
397, 897.
Page.
Hang up. Hang up. That with regard to the statement made in paragraph 6, the equivalent the land covering the number 310 and 360 are surrounded by railway land and railway colony comprising quarters, drain, roads, etc. The railway quarters number such and such are existing on the land and that number such and such, as already stated above. At that the quarters were constructed and around in and around in the year 1980. And at that time, none of the patta holder neither raised any objection for construction of the railway quarters on the same land or not claiming any land of their own. Basically, it is their obligation to establish their right, title, and interest over this book land. And this right, title, and interest can only be established by instituting a civil suit. They are bending upon their case on a revenue record. That is a thicker institution.
Yes. Yes. That's all? Yes. May it please your lordship. My lord, my learned friend, please come to the judgment, my lord, page 31. Yes. My learned friend did not read paragraph 10. Paragraph 10. 10 of the judgment.
Sri B.J. Talukdar, Lanet Standing Council, Revenue Department has submitted that pursuant to the direction of the court, necessary survey was carried out by the Latmandal, which establishes that land of the petitioner is under occupation of the railway. The Lanet Council for the Railway fairly submits the document supports the case of the petitioner. This he did not read, my lord. For the revenue, sorry, fairly submits that the documents support the case of the petitioner.
That is only on this basis.
Yes.
The learned
Yes.
single judge has allowed the writ.
Now, my lord, let me first address your lordships. Now, my learned friend is repeatedly making one submission that instead of filing a civil suit, we have filed a writ petition. We are trying to establish our right, title, and interest. That is not the case, my lord. The reliefs read for in the writ petition clearly indicates we are claiming we are the owner of the land. Since you are not the owner, you should vacate the land. That is the only thing. And learned single judge having found that already quarters, drains, roads are there, therefore an option has been given to them
Either to vacate or to give.
either to vacate or to pay compensation. I think, my lord, that is absolutely within the, my lord, competence of a 226 court, my lord. Now, much is said about disputed questions of fact. Before I even lay before the facts, my lord, I'll just rely upon one judgment of the Supreme Court. Para 2004, 3 SCC 553. This is precisely on the question of what is the scope of a 226 court to go into disputed questions of fact. I'll have your lordship's kind attention to para 16, 17, 18, and 19.
ABN.
ABL, yes. Page 567. Let me steer clear through this controversy, my lord. Normally, to what extent your lordship's in exercise of power under 226 would go? A perusal of the judgment, though, shows that a writ petition involving serious disputed question of facts, which requires consideration of evidence which is not on record, will not normally be entertained by a court in exercise of its jurisdiction under Article 226 of the Constitution of India. This decision, again, in our opinion, does not lay down an absolute rule that in all cases involving disputed questions of fact, the parties should be relegated to the civil suit. In this view of ours, we are supported by the judgment of this court in the case of Gunawanto Court, that's famous case of 1969. Though the High Court observed that they will not determine disputed questions of fact in a writ petition, but what facts were in dispute and what were admitted could only be determined after an affidavit in reply was filed by the state. The High Court, however, proceeded to dismiss the writ petition in limine. The High Court is not deprived of its jurisdiction to entertain a petition under 226 merely because in considering the petitioner's right to relief, question of fact may fall to be determined. In a petition under Article 226, High Court has jurisdiction to try issues both of fact and law. Exercise of jurisdiction is, it is true, discretionary, but discretion must be exercised on sound judicial principles. When petition raises questions of fact of a complex nature, which may for their determination require oral evidence to be taken, and on that count, High Court is of the view that dispute may not be.
Mr. Chaudhary,
Yeah.
There is no quarrel about that
Yes.
proposition of law.
Yes,
But so far as regarding 2 or 3 questions which you have to answer.
yes.
So far as the land was acquired by them or in their possession since 1958. They have constructed the roads, etc. in the 1980. That is an admitted position. You have not disputed that. Then after 1980, for the first time, you approach by way of filing writ petition in the year 2013. Right? First writ petition in the year 2013 that was disposed of for demarcation and purge. First question is this regarding the delay. The second, in your writ petition, you have simply prayed for a direction to vacate the land.
Yeah.
And for that purpose, for vacating the land, this after so many years in 1958 to around
2013.
2013, You have not raised any objection and then you have come. Okay, now this land should be vacated and a direction be issued to vacate them. For that purpose, a suit for eviction is not the proper course. How this written Article 2?
No, my lord,
can be maintained. sir,
suit for eviction is of course a remedy.
Is a
But my lord, if the facts are of such a nature, where there is no dispute of a nature that a 226 court cannot go into, in which case a 226 petition would lie, my lord. Now, where are the disputes?
too many questions, sir. So far as regarding, suppose this adverse position theory, that may also come.
No, my lord, they have not mentioned one thing. They have filed a writ petition in 22. That gave the cause of action to us. Please, my lord, we have filed an additional affidavit where we have brought on record all those aspects.
What 2000?
Yes. They filed a writ petition, railway.
2022.
Yes.
2022.
No, please, Lordship will my lord, kindly come to.
This writ petition is of 2013.
No, I'll come to that, my lord.
Yes.
Please come to page 180. It's part of our additional affidavit.
Yes. 180.
Yes, madam. In fact, the order starts at page number 176.
176.
Please come to para 3, my lord.
176.
176, it starts.
This additional affidavit you have filed in
Yes, my lord.
May 2022.
1 second, my lord. Tarikh to idea rukne.
Because there is numbering, there is some confusion about the numbering. 198, yeah. This
14 September 23. Now, my lord will kindly come to page number 180. Please
Yes.
come to para 3. Union of India representing NF Railway has projected that NF Railway had acquired about 502 bighas, 4 quarters lessers of land in Maligaon and Gotanagar area under Ramsarani Mauza, which is presently Jalukbari Mauza in the district Kamrup, India 58, by virtue of a land acquisition notification dated so and so and so and so. It is projected that railway authorities were provided advance possession of the same land, and in respect of such possession, railway had also deposited an estimated land acquisition of so and so. It is also projected that as per mutual agreement between railways and the government of Assam, a portion of the land was handed over to the state government for construction of Pandu Port in lieu of so and so, so and so, so and so. Now, my lord, this is how the facts are narrated. Eventually, my lord will kindly come to the operative portion of the order at page 192. Sorry, my lord, page 191.
This writ petition is for what?
This writ petition was filed by the railways, my lord.
For what?
Basically, they wanted to say, my lord, that the whole land should be demarcated and all, the entire position for land, my lord. From there it
They are
emerges.
complaining that this whole possession of the land has not been
Yes.
given to them.
Yes. At page para 24.
Yeah.
At this stage, Learned Standing Council for the Railway has referred to the statement made in sub-para 7 of para 5 of the additional affidavit filed by respondent number 3 in WPC number so and so, wherein it has been projected that new DUG number 317 is corresponding to old DUG number so and so. However, regarding acquisition of railway land, the plot of land measuring 42.9.22 hours covered by DUG number so and so is acquired by as railway land. On the contrary, the same respondent number 3 in his affidavit in opposition filed on 1/8/22 in the proceedings of WPC has mentioned in para 4 that new DUG number so and so village Gotanagar is corresponding to old DUG by resorting to the name of the previous partner by striking out the name of the railway land. In view of this said discrepancy observed in the statement made in para 9 of the affidavit in opposition filed by the circle officer in so and so of the additional affidavit filed by the same authority in so and so, the concerned authorities under establishment of Deputy Commissioner Metro shall also ascertain the correct position of the said land and shall record it in the order that would be passed in the demarcation case. Before parting with the record, this court is inclined to clarify that this court has not adjudicated the right, title, and interest of any of the parties to this writ petition, and therefore, if there is any interstate dispute between parties with regard to title or ownership of the said land or right of railway authorities to evict encroachers, the respective parties would free to approach competent court of law forum as the case may be. The demarcation process should be brought to its logical conclusion, preferably within a period of 2 months from today. The railway shall be ready and willing to provide boundary pillars of the same demarcation of the land. So, my lord, in substance, this honorable court directed for demarcation of the entire land. Now, my lord will kindly come to page number para 5 of this affidavit, my lord, at page number 125. Page 125 of the same affidavit. It was an additional affidavit filed by us. That by letter dated 19/11/22, the surveyor submitted a survey report to the Joint Director of Survey Assam with regard to DAG number 316, with which we are concerned, by stating that as per survey, it was revealed that land measuring 1/17 lecha under DAG number 316 is under possession of the pattada, that is respondent. It is thus apparent that remaining land under the said DAG is under illegal possession of the railway. NF Railway filed a writ petition before this honorable court, being WPC, by projecting that they had acquired 502 bighas of land at Gotanagar under so-and-so in the district of Kamrup in the year 1958 by virtue of land acquisition notification dated so-and-so. The contention of railway was to the effect that although advance possession of the land was provided to them, they had paid acquisition compensation, and government of Assam had also given railway about 45 bighas and so-and-so lessons of land at Gotanagar and Maligaon. In this regard, land acquisition notification was issued by the state government for acquisition of the land, and railway are in possession of the said land. The further grievance of the NF Railway was that they had been requesting Deputy Commissioner for initiating steps for demarcation and identification of the railway land measuring 45 bigha, but district administration has not taken any steps for demarcation of the land. That in compliance of a direction of this honorable court passed on so-and-so, and in aforesaid writ petition, a report has been prepared on the basis of the survey of the land in question in cooperation with Joint Director of Survey in Assam, in presence of NF Railway officials. A detailed report in this regard was filed by the Circle Officer, Guwahati Revenue Circle, by of additional affidavit in so-and-so. So, my lord, page 138 to 175 is the part of the survey report. My lord, DAG number 316 new and 3110, over which we have claimed, this is not included in the notification, my lord. It clearly says it belongs to the petitioner. Now, what is the disputed question of fact that I should go and establish in the title suit, my lord? My humble submission is, my lord, yes, ordinarily not. Always the language used is ordinarily. End of the day, my lord, it's a discretionary jurisdiction. Even otherwise also, lords may say, all right, even if there is a, but where is the dispute? I can appreciate. In a given case, it may not be.
Was the measurement of the disputed land?
Yes, page 135 onwards, my lord.
How many bighas of the land is?
My lord, before that, if your lordship would kindly permit me to place one page from the memo of appeal, the notification under section 4 at page 103.
That is for the whole land, na?
Yeah, no, my lord. That does not include that.
That's right. What I'm asking, what is this area of the disputed land at present?
4 bigha, 19 lessa.
4 bigha.
Now, my lord, this 103 notification of June 21, 1958, it does not include, my lord, the disputed lands. That's why I'm saying, let them produce the notification of section 4 under the Artswell Land Acquisition Act.
Yes, that is there.
No, my lord.
This page number 103.
Yes.
What is it?
No, my lord, the dags are,
This is what the description of the land of
my
21st
lord.
June to 1958.
no, my lord, all dags were
It is
five
hereby
forty-eight.
notified land
No,
is-
548 and 679. Old dags were, my lord, old dag 540 corresponds to 316 new, and 679 corresponds to 310, which
No,
are the disputed dags.
This is what the land, this section 4 notification is this, na?
Yes, my lord.
So you mean to say that this land of this particular Doug is not
Yes.
covered under this?
Yes.
We understand that.
That is the case.
Yeah.
Now, my lord, will see this report. Entire report is there. This does not include old, my lord, 548 and 679. Then we got emboldened, my lord, whatever doubt we had. Then we brought it by an additional affidavit. Now, Lanet Singhal just says, since your occupation of the land will not disturb you. End of the day, my lord, they are serving a public purpose that we cannot deny. Therefore, I am entitled to compensation in accordance with law. So that is our case, my lord. In my respectful submission, my lord, the plea that merely because some disputed question of facts are involved, a 226 court will not go into, that always may not be correct. It all depends upon the facts of each case. And in fact, my lord, lordship knows that judgment of 1963, where even a 226 court was directed to hand over possession also. Even our High Court has done, my lord. In fact, I appeared in one of the case.
Yes.
So therefore, my humble
Fine,
submission
yes,
is, my
yes,
lord.
why not? Yes.
Therefore, my humble submission is,
Yes.
there is no dispute that the land over which we have a claim was not acquired by the railways, but coincidentally, the land is under occupation of the railway. Fine.
Yes.
That
Yes.
being the position, my lord, there is nothing to interfere with the order of the learned single judgment.
Jodi, you want to say?
And they are establishing their case on the basis of relevant report. And that is Chita.
That?
Chita.
Yeah, that's right.
Chita.
That Jamabandi.
Jamabandi.
What else is there?
Jamabandi does not confer any right taking or interest to them. You have to establish your right taking interest independently.
Then a person having his right over the land, how can he establish by which document?
Who is title?
Title, on the basis of the title, this entry in the revenue records.
On the basis
On the basis of the title, they are having hereditary right. The land belongs to their forefathers, and now after their death, mutations were sanctioned in their name, and as such, their names were entered into the Jamabandi.
Yes, that is correct.
That is why the Jamabandi, in Jamabandi, if their names are there, then
So Jamabandi, in Jamabandi, their names are not there, Lord. So far the case is concerned, Lord, they wanted to say that we are the recorded Patatan. And on the basis of
so
this
in the
recorded
revenue
Patatan,
record,
we want to.
in the revenue record, their names are there,
Yeah, in the revenue record, their names might have been there, Lord.
recorded as Khatidar.
But they are,
Recorded as Khatidar.
no,
Pattadar.
Pattadar.
Same thing.
Oh, one and the same thing, Khatidar and Pattadar, yeah.
but they are to establish the right title or interest. Lord.
On the basis of this Jamabandi, the land which is not acquired or not in possession of the land, they can sold this land on the basis of that pattadari. They can transfer the land in favor of the other persons.
No.
How can it be, sir? The person whose name is entered in the revenue record as a pattedar can very well sold this land as transfer this land by way of sale to any person, other person, until and unless there is any restriction under the law.
The Lord, is perfect. That didn't affect.
Which one?
Just now happened.
And the judgment is there, but that Narendra Jitendra Singh.
Yes, paragraph 5.
Yeah, paragraph 5, we have already gone through that.
It is not at the
Fiscal, the entries in the revenue record or Jamabandi have only fiscal purposes. That is in respect of mutation entries, sir.
It is not the dispute. The dispute with respect to the mutation entry. There is Jamabandi, etc. And in the revenue record, the petitioner herein submitted an application to mutate his name on the basis the alleged will dated such and such, executed by such and such. Even according to the petitioner also, Timothy such and such died on such and such. Date. On the record, it emerges.
Yes.
Now, look, be that as it may,
Yes.
as per the settled proposition of law, mutation entry does not confer any right, title, or interest in favor of the person, and the mutation entry in the revenue record is only for the fiscal purpose. As per the settled proposition of law, if there is any dispute with respect to the title, more particularly when the mutation entry is thought to be made on the basis of the will, the party who is claiming the title right on the basis of the will has to approach the appropriate civil court. Yeah, appropriate civil court.
Yes.
And get their right crystallized only thereafter. The basis of the decision before the civil court necessary mutation entry will made. Here, our claim is that this is our land, and we have constructed the quarter, and we have constructed it in the year 1980, and you have approached before the revenue authority for demarcation of your land in the year 2013, and the revenue authority simply states that the land, the particulars which you have furnished to us, is occupied by the railway authority. That revenue authority has not said so that this is your land. Simply say that the land which you are claiming that is being occupied by the railway authority. Based on that observation only, they approve before the dishonorable court for declaration of a right taking it. Next, now your lordship may kindly. Sorry.
There is a report. Report.
Is that this circle officer report is there on the?
Yes, madam.
Where is that?
Yes. That is yes. Circle officer's report, my lord, is at page 82. Only thing is, my lord, I think Honorable Justice Mr. Nair will have to help it out somehow, my lord.
Yeah.
It's
Page
in
82.
vernacular, my lord.
Yeah.
Yes.
Page 82.
লাটমণ্ডল আৰু চুকাফাৰ প্ৰতিবেদন চোৱা হল আবেদনকাৰী শ্ৰী কীৰ্তি চন্দ্ৰ
Just a minute. Huh? Yes.
লাটমণ্ডল আৰু চুকাৰ প্ৰতিবেদন চোৱা হ'ল আবেদনকাৰী শ্ৰী ক্ষিতীশ চন্দ্ৰ কৰ্মকাৰৰ আবেদনৰ ওপৰত মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ে দিয়া নিৰ্দেশ মৰ্মে সীমা গোচৰ পঞ্জীয়ন কৰি সীমা সমজুৱাৰ নিৰ্ধাৰিত তাৰিখ উপস্থিত থাকিবলৈ জাননী জাৰি কৰাত আজি ইংৰাজী 31/8/13 তাৰিখে ভূমিলেখ্য কৰ্মচাৰী চৰকাৰৰ সৈতে সৰজমিনত যায় সৰজমিনত জোখমাখ কৰাত আবিদত ম্যাদী খ্যাদ ইমান 310 নম্বৰ দাগৰ ইমান আৰু 316 নম্বৰ দাগৰ 51.50 জমি ৰেলৱেৰ আৱাসগৃহ ৰাস্তা ও নলা হিচাপে আৰু 280 নম্বৰ দাগৰ 3 জমি চেণ্ট মেৰী স্কুলৰ ৱালৰ ভিতৰত দখলত থকা জমি হয় আৰু সেইমতে আবেদনকাৰীক সীমা বুজাই দিয়াত আবেদনকাৰীয়ে স্বাক্ষৰ কৰি দিয়ে গতিকে গোচৰ সমাপ্ত কৰা হওক So my lord, when it is later.
Just
No, 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 nothing. And the other part they say is within their wall. Not that it is that it can be very much doing. That is no, no, nothing, no, nothing. No, no, sir.
yes.
No, your lordship,
Applicant.
so far my judgment.
Application of কর্মকাণ্ড আবেদনের উপর on the basis of the application of কর্মকাণ্ড মহামান্য নির্দেশ কর্মে বিমান গোচর পঞ্জীয়ন করি they have raised the boundary district and বর্তমান সমুদায় নির্ধারিত তারিখত উপস্থিত থাকছো date was উঠলে আনে তারিখ ভূমিলে কমিশন সরজমিন যুগমান সরজমিন the plot they have indicated this plot was there they have measured that plot. করার আবেদন farm মেয়াদি so and so আবেদিত the applied মেয়াদি so and so number পট্টা so and so দাগর 2.6 আর 316 নম্বর দাগর 51.5 আর জমি রেলওয়ের আবাসগৃহ আৰু রাস্তা ও নালা হিসাবে so that is being created as a building nala and out of that 280 number that 3 are জমি St. Mary's School of wall or ভিতর within the wall of the আৰু সেই মতে আবেদনকারীর সীমা বুঝাই দিয়াত আবেদনকারীয়ে স্বাক্ষর কৰি গতিকে গোচৰ সমাপ্ত কৰে So he said that this is your no, this is it. No, no.
Yes.
My lord, this report in substance says this land covered by the patta number 310 and 16, 316 with which we are concerned, it
They
was
have
found to be in
constructed
possession
road,
of railway.
road, they have constructed.
Where
road,
railway have constructed quarter, drain and road.
Yeah.
And part of the land that is 3R
within the school.
wall, is boundary
Saint
wall of
Mary's
St. Mary's School.
For my judgment is simple, Lord. Just now I have referred. May I read paragraph 6?
Jitendra Kumar.
Yes.
Yes.
May I read that?
Yes.
Right from 1997, the law is very clear. In the case of such and such, reported in 1997 7 SPC, page 137, this court held an occasion. This court had an occasion to consider the effect of mutation, and it is observed and held that the mutation of property in the revenue record either creates nor extinguishes the title to the property. nor has any presumptive value on title. Such entries are relevant only for the purpose of collecting land revenue. Similar view has been expressed in the series of decisions thereafter. In the case of such and such, 2007 6 this is the 186. It is observed and held by this court that an entry in the revenue record does not confer title or title on a person whose name appears in the record of rights. Entries in the revenue records of Jamabandi have the only fiscal purpose, that is the payment of land revenue, and no ownership is conferred on the basis of such entries. It is further observed that so far as the title of the property is concerned, it can only be decided by a competent civil court. Similar view has been expressed in the cases, these are the cases, my lord. So in view of the above settled proposition of law laid down by this court, it cannot be said that the High Court has committed any error settling such. That is.
No, that's a settled law. It's a law. It's illegally occupied by the resident from the land of the landowner and themselves are typically being granted as such. So this allows the purchase.
So they are bending only on the report of the circle officer. And the circle officer has not said anything in their favor. Circle officer simply said that the land in question which you have is under occupation of the railway authority and they spend money.
Just to reply on the judgment, my lord. My lord, that judgment is absolutely correct, my lord. Nobody is disputing that proposition. That per se, an entry in the mutation or in the record of right per se will not confer any title. We are not on that. My lord, here is a case. I can appreciate a private dispute between two private parties. One is claiming I purchased this land. He says you have not purchased this land. Now, my lord, railway is an authority under Article 12. They are not supposed to be litigants. My lord, their right flows from the fact that this land was acquired from government of Assam. Now, in that process, if a citizen can show that this particular plot of land was not acquired for you, well, for that, why should I go to a civil court, my lord? How that proposition of law applies here? They'll have to first show, my lord, that this particular plot of land which they're possessing, as rightly observed by learned secretaries, was acquired for them. Their right will flow only from that. Until and unless they can show, my lord, their right is clouded. Now, therefore, the burden shifts on us. But we have shifted our burden by showing, my lord, all the survey reports and all, the circle officer's report. Therefore, my lord, this judgment, with great respect, I'll submit. In the facts of this case, may not have any application.
What is it?
For hearing, item 13.
Item number 15. 13. That settlement of our market. We were delayed by 2 days. And L1, L2, L1, L2, L1. So the what was L2 on 6. We want to deposit of this which a 14 being delayed. Cancel. Complete with it.
कोर्ट में ऐसे भी ज्यादा no. Yes. Yes. Arjun.
But market is being operated by the
Right. जो भी रिजल्ट क्या था Okay. Thank you.
For pronouncement of judgment, item 6.
The appeal has been dismissed. But there will be no order of recovery for the period of service rendered by the appellant on the strength of interim orders of this court. Go through the reasonings we have given.
For orders, item 1.
Counsel, you were supposed to take certain
My lord, the
steps.
problem is this, my lord. I am unable to contact my lord.
Whether this,
I communicated to him, my lord, to his advocate also, my lord, for filing impeachment application.
is interested in continuing with this. Huh?
I don't think it's from last 3 or 4 occasions, you have I have tried my.
What is this petition is for?
My lord, it is in respect of my lord, in D2 water supply scheme, your lordship. It was not implemented, so it's on the because of the fund and all that. So on the last occasion, learned additional advocate general informed the Honorable Court that communication was given to donor ministry for release of fund. It's in groups.
Right. Okay. This PAL petition is filed by the petitioner, essentially raising a grievance regarding the non-completion of the augmentation of greater in inverted commas augmentation of greater deep water scheme in Karbi Anglong district. Full stop. Unquote. Unquote. Full stop. It is the main concern of the petitioner that the government of Assam is not taking any effective steps for the purpose of implementation of the above referred water supply scheme. Full stop. Then it on 23/2024, then the additional advocate general has placed on record a copy of communication dated 30th of November 2023 sent by the Additional Director Transformation and Development Department, Government of Assam, to the Deputy Secretary, Ministry of Development of Northeast Region, Government of India, Donier, Government of India, for the purpose of for the purpose of supplying some information so that the central government may release some fund for the purpose of implementation of the above referred water scheme. Full stop. Learned counsel appearing for the respondent. For the respondent state, you are for the respondent.
I'm for the PhD department.
PhD department has submitted that the matter is under active consideration with the central government, and the government is, the state of Assam is hopeful that the necessary funds will be provided by the central government for the purpose of implementation of the above referred water scheme very soon. Full stop. Learned counsel appearing for the petitioner has submitted that he is not able to make any contact with the petitioner since long, and therefore pleaded no instructions in the matter. Full stop. Taking into consideration the fact that the central government, that the state government has already approached the central government for the purpose of providing fund for implementation of the water aforesaid water scheme, and the matter is active consideration with the central government. We deem it appropriate to close this PIL petition with the expectation that the central government will soon release a fund for the purpose of implementation of the aforesaid scheme, and on availability of the said fund, the state government shall implement the scheme without any further delay. Ordered according. Water supply.
Item number 2 and 3.
Wants to withdraw the
Yes, I'm the respondent one.
dismisses. What about this? All the IAs are also disposed of. The connected IAs so and so are disposed.
Imprimatur, there is an imprimatur, maybe packet matter.
Once we are dismissing the writ petition, still do you want some order?
My lord, we are going to again to the NIT, my lord.
You do it,
Yes, my lord.
do it.
If
Wants to
any
withdraw.
observation on Article 14 violation, my lord.
Withdraw, dismissed as withdrawn. That's all. IAs are also disposed of.
Item 4.
Go.
What's the directed to find an affidavit, my lord? Affidavit been sent for vetting, my lord. Even I received the
Is there
affidavit.
a direction from the NGT on this matter itself?
Yes, pursuant to NTD's direction, this report was prepared.
So once the matter is pending consideration with the NGT, or it is
I
pending?
don't think, it is pending consideration,
Pending consideration.
No, it's not.
So what's the final order ultimately passed by the NGT?
This keep, I'll have to check, but.
Mr. Das, the problem is this, that once the NGT has has already taken up the matter and passed certain orders, then any further order or any other order in this petition may contradict that situation. Or there are possibilities, there's some contradictory orders.
If my lord comes to para 3 of
the matter.
So, whatever instructions are here, if any proceeding is pending, what is the nature of?
Yeah, they will take it.
Okay, number is very to position, action plan of the, and the entity. Then action.
Mr.
Hello,
Das,
if I may just explain, my lord, NGP passed some order in other subject, my lord, concerning the river cleaning.
sir, kindly
And
consider,
it-
kindly consider, sir.
Yes,
In compliance of the Honorable National Greens Principal Bench, New Delhi, in the matter
news
news published in the Hindu
Yes.
regarding this very much river.
Authored by Jacob Posti titled More River Stretches Are Now Critically Polluted CPCB. Government of Assam.
Ultimately, we just want to know what type of proceedings or what nature of proceedings are pending with the NGT, whether these issue which you have raised, which is raised in this petition,
Yes.
is covered under that or not. So at least one authority, either the High Court or the NGT, may ponder over the situation or the problem, and then if some orders have been passed, then why should we look into all this?
Going by the contents of this, my lord, I don't find anything that this was as per the
Please get it.
direction. I'll
Please
check,
get
my
it.
lord, I'll check.
Okay, learned counsel.
But in the meantime, they
I will
will
find
find
one.
the affidavit.
Yeah, that is,
I will get
Mr. S.
Yes, Bora.
as for
Yeah.
the respondent.
Mr. Das, amicus curiae is directed to verify whether in relation to the very subject matter involved in this petition, any proceedings before the National Green Tribunal, New Delhi is pending consideration or disposed of. Full stop, Mr. Das prays for and granted 4 weeks time
Hello.
to do the needful. In between, Mr. S. Bora, Senior Counsel GMC, may file the counter to the writ petition.
No, only then additional affidavit, not to be directed on the last.
Additional
Being-
affidavit as directed earlier within by the next
No, no.
date of hearing.
Directed on 9/4.
Yes,
Standing council.
Pending council, GM, which him.
standing counsel, senior counsel, not senior counsel is standing.
It needs to be fixed. It needs to be. Yes.
Thursday, whatever the 4 weeks, after 4 weeks and Thursday.
My,
Item number 5.
Five, the petition person, he was to file a reply. Shall he did.
Okay.
Perhaps my lords are discussing about this. This is a sticker, my lord. It can be implanted any part of the body.
You have obtained it from where?
This is my lord, this is.
From the bottle?
Yes, I have pasted one. On one occasion, there was a deliberation to what was it exactly. So I had this. So my lord, this is a multi-layered film which is used to protect the, so which is to protect the source.
It's plastic which is banned.
No, my lord, it is not banned, it is exempted. It's exempted. We have filed affidavit, my lord.
You have filed affidavit.
Affidavit
of the board is also.
Who's for the petitioner?
The petition person, my lord, Dhrupajyoti Bora, is not there.
Where is your affidavit?
My lord, my affidavit in opposition is there. It starts at page 33.
Page 33.
Oh. And at 34, Categorically, we stated by what is this? Paragraph 3, paragraph
Paragraph
5,
three,
3, 5, and 6. Madam.
three, so that your opponent do not want to make any comment.
No, no, Madam, paragraph, paragraph 4, my lord.
Oh, that with regard to the statement, your deponent begs to state the Assam plastic as amended cannot cover.
Affidavit of what?
Plastic comes with amateur license.
Affidavit of the, no, 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 more. Excise department, not three. In that case, the petitioner should have SL because now plastic bottles are also in circulation.
Plastic bottle?
Bottles are also in circulation, my lords. PET bottles, my lords. They have not SL anything.
Mr. Gogoi, what to do? Some people are concerned with what is outside the bottle, some are concerned with what is inside the bottle. And as judges, we have to deal with both these.
Not the packaging, basically it's a seal, my lord.
This PIL petition after 2 weeks, date, now whatever the Thursday, after 2 weeks, any Thursday. 12/6. On 12/6, after showing name of Mr. Dhruv Jyoti Borha, the petitioner appearing in person in the, reflecting the name of Mr. So-and-so, appearing in person in the cause list.
Well, always.
Since his name is not there, maybe he's not aware about that.
Well, some incident also happened to him. Well, he's one of the his elder brother met an accident and had an untimely death. Well, maybe that also maybe some reason.
Maybe for that.